Marilyn Manson has had good success in defending himself in the cases against him. He's got strong statute of limitation arguments in New York, and back in California, both federal cases, Smithline and Bianco, are terminated. There's only one active case against him in California, the Jane Doe case. But even though he succeeded in having Ashley Walters' case tossed on a motion to dismiss, she has appealed, if you remember. Well, that case is going to come back. And I want to make this video to share with you the information I have that shows that and analyze it with you, but also just to say, I told you so. Now, let's look at her arguments to the California Court of Appeals and Manson's counter-arguments. She's got a really long brief. I'm going to send, or have sent by the time I've done this video, all these documents over to the Manson cases because I just glanced through them just now, just got them. And you can probably find them once she posted in their greater glory of 50 pages or however long each one is. So anyway, to boil it down, the arguments are as expected. The court shouldn't have tossed the case, or at least should have let her amend it again. Plus, it doesn't really matter because the California legislature has passed laws reviving her claims. She had 8 claims in her suit: sex discrimination, sexual harassment, sexual assault, you get a theme here, interference with the exercise of civil rights, sexual battery, intentional infliction of emotional distress, battery, and assault. At the trial level, the court gave Walters a chance to revise her lawsuit after the first one, and she did, filing a second amended complaint. On the motion to dismiss that, though, the court granted Manson's motion to throw it out with prejudice, which means you can't come back and file it again. If you want to do something about it, you have to appeal, which she did, and no further leave to amend. The court said, look, the original 2-year statute of limitations says run. The complaint doesn't support the discovery rule we'll go over. And the 10-year statute of limitations that got passed, well, that's not retroactive. Curiously, I don't think the order addressed estoppel, which does come up on appeal. So Walters comes out of the gate with this equitable estoppel argument, saying Manson should be estopped, in other words, prevented from relying on the statute of limitations due to violence, threats, and intimidation the defendants directed toward her during and after her employment. This argument has worked for Bianco in her federal case, if you recall, not to win the issue, but to keep the case from being dismissed, to say this is a fact issue as to whether this would bar the statute of limitations or not, because that's the posture of the case, not weighing evidence. It's just, should it be dismissed right now? She then says the discovery rule applies. She did not recall at least some of the defendant's wrongful acts until 2020 and had suppressed them as a psychological trauma response. But then she unleashes the beast, the revised statute of limitations, saying in her brief, moreover, recent changes to the Code of Civil Procedure, effective January 1st, 2023, revive all of Ms. Walters' claims. The trial court ruled in part that the 10-year statute of limitations for sexual assault claims did not apply retroactively. However, these amendments explicitly revive lapsed sexual assault claims based on conduct all the way back more than 10 years to January 1st, 2009. These amendments also revive claims against entities like Marilyn Manson Records, which she sued, for covering up sexual assaults through the use of non-disclosure or confidentiality agreements, along with any related claims, including but not limited to wrongful termination, harassment, all of that. It's things that arise out of the assaults. So she says the amended version of these statutes, well, guess what? They revive her claim for sexual assault by defendants going all the way back to 2010. No problem. And it goes beyond that, exposing Marilyn Manson Records to liability for covering up Manson's alleged conduct toward Ms. Walters, and then revives all of the related claims, the discrimination and the other things, all arising out of the same course of conduct and actions. Now, she lays out in her complaint that she was diagnosed with complex PTSD, major depressive disorder, and generalized anxiety disorder, which she says manifested in repression of many of the most traumatic events involving the defendants. Until these memories were more fully unlocked, she was unable to reasonably inquire into or investigate her possible claims. That's what the discovery rule is about. If you didn't know about the basis for your claims and you had no reason to check into it, then the statute of limitations could be told. Now, she says she went to a support group, she got therapy, and once she realized what had happened and the extent of it, etc., she quickly sought counsel and pursued the claims. Now, remember, for purposes of a motion to dismiss, and that's how her case was thrown out, any and everything she alleges, basically, is going to be taken as true for the purpose of the motion, not as facts in the case, because the judge is there at that stage really to test whether she stated a claim and whether there's a fatal defect on the claim as alleged. And that's it. There's not, well, I think it's true or I think it's not true or whatever. If she alleges a set of facts that would support a legal theory of relief, the case should go further than that. They could still be tossed out later on evidence or whatever, or maybe not. But that's the purpose of the motion to dismiss. Disputes of evidence would come later. So her first argument is the court was just wrong. The second complaint was good enough. It invoked, she says, those defenses against the statute of limitations, not as established, but at least as issues that should be tested one way or the other by evidence, the discovery rule and the estoppel. And so it shouldn't have been thrown out at the beginning of the suit. Here, probably wisely, she even quotes and references at length the federal judge's decision finding similar accusations by Bianco raised a fact issue on estoppel, and so an order of dismissal in that case based on the complaint itself was not appropriate. Was that decision precedent? Maybe in the street use of that word, but legally it is not binding precedent on the California Court of Appeals. Now, the Court of Appeals may find the reasoning interesting or not, compelling or not, but on this matter of state law, it has no obligation to defer to the federal district court. It really would be the other way around precedent-wise on state court claims. But still, again, I think it's wise for her to use this because it shows at least one independent court found a fact issue in a similar case, and a motion to dismiss should be denied if there's any alleged legal theory that would result in relief. Let's move on to her ace in the hole. The statute changed. The trial court had found the 10-year statute of limitations did not apply retroactively. But effective January 1st, 2023, it was revised to make retroactive effect clear. This section applies to any action described in subdivision A that is based upon conduct that occurred on or after January 1st, 2009, and is commenced on or after January 1st, 2019. If it would have been barred solely because of the applicable statute of limitations, the claims are hereby revived and may be commenced until December 31st, 2026. But that section only applies to a fairly specific definition of sexual assault. However, she also cites another section of the statute that was changed that the entity defendant claims, or an entity's, in this case, a company, okay, or something like that. It can be even a sole proprietor, I think, but whatever, an entity, that those claims are similarly revived based on an attempt to cover up. That's one of the activating factors that gets you this retroactive statute of limitations. And that's important because under that section, it's not limited to just sexual assault claim. It also revives similar claims or related claims. That's basically her argument, is all of the things that you can think of. The judge made the wrong decision to begin with. The judge should have let me amend my complaint again. She cites some law for that, saying that should be freely done or whatever. And then the statute changed. So eventually, it all looks pretty compelling, at least to some degree. In fact, it's so compelling that Manson's lawyers right out of the gate concede that she's correct on the claim for sexual assault. He says the judge was right at the time, but the law has changed. And for the claim involving sexual assault, it should be revived, further proceedings, reinstated, but not these other claims, Manson says, and we'll get into that. But again, just that alone means her lawsuit, if the Court of Appeals agrees with both parties who agree with each other that the law has changed here, her suit could go forward on the sexual assault claim against Manson. So that's a big deal if you care about cases against him for this kind of activity. However, Manson's team does not concede that all the rest of the claims should come back, or even that they should come back against him or the entities or whatever. And he addresses her arguments as to delayed discovery. The brief literally says, no way. Manson says this doesn't involve hidden facts or latent injury. Everything she's talking about is stuff she knew. She was an adult, fully aware of what was going on. She reacted to things. Sometimes she got away from situations. How can she act like she didn't know what was going on with her? He cites a case saying discovery rule applies if you do not have reason to know the factual basis for the claims. And he says there was nothing to discover later. She knew it all back in 2010 to the degree that it happened. Now, as to equitable estoppel, Manson's team says allegations that he made threats against other people, well, that's not an excuse for her to wait a decade to file her claim. But there's more to it than that. Well, Manson's team argues even Walters doesn't claim to have forgotten or repressed it all, and that's why she has to bring up equitable estoppel. It's a pretty good point, which that's based on threats, the estoppel part. They argue her suit shows that she knew about the acts against her. She never forgot about them, certainly not all of it. And so she can't claim that she first knew about abuse by Manson a decade after it occurred. And then again, I think that's pretty solid. Now, the next argument on the estoppel, that's a little bit more of a mixed bag. Manson's team says the alleged threats by Manson were vague and directed to other people. But his counsel admits that the allegations are unsavory. And I would suggest reading them, and you will find out that that word certainly applies to the allegations. But to me, if you read it, the alleged activities, if they occurred, seems to be a mix of things against her and others. And I don't think it's necessarily fair to say it's all against others. If what she's saying is true, I can understand what her narrative means, whether you agree with it or not. Now, finally, on the revised statute of limitations, Manson's team concedes it does revive a claim, as I had told you before, but only under the specific definition of sexual assault. And so Manson's team says it only affects one claim, and that's a good argument. Still, you'd rather it not be there, right? The whole point was to get her suit gone, and it's going to come back even by his own attorney's arguments. But that still leaves the other revised statute of limitations out there for the entities that can be subject to retroactive statute of limitations if there's an appropriate allegation of a cover-up. The statute even mentions confidentiality agreements as a method of cover-up. Manson's team says, yeah, but if the agreement is signed before the abuse, it can't be a way to cover up later abuse, and the statute mentions covering up prior incidents of abuse. Well, I think that really depends, doesn't it? Doesn't it depend on how you use the agreement after the abuse occurs? So I don't know about that. The big impact here is if the entity clause is able to be used, it revives related claims. And that's not as narrow as the definition of sexual assault. Like it even talks about harassment and wrongful termination and stuff like that, and just related claims. So now Manson's team throws one final shot saying, well, even if she is right, Your Honor, or honors, as the case may be here, it's only as to entities and not the individual Manson. And that might be right. I understand that from the language of the statute. But if she can bring all these claims back against Marilyn Manson records and entities, and the sexual assault claim against Marilyn Manson, well, then she's pretty much back in the game, isn't she? So the summary is both parties agree that Walter's claim for sexual assault should be reinstated based on the change in the law. They disagree as to whether the entity clause revives other claims based on the confidentiality agreement. And if it does do that, whether it's for Manson and Manson records or just Marilyn Manson records. But the suit's coming back. It's just a matter of the scope of it. And given the procedural posture, it seems likely claims beyond sexual assault will come back as well, at least as to Marilyn Manson records. Now, I'm not personally as open-minded about the repressed memory thing and the estoppel based on threats thing as the federal court was. But the federal court said, for example, in the Bianco case, that was enough to let the case proceed past a motion to dismiss. So I wouldn't personally be shocked if the Court of Appeals in California agreed based on the allegations as stated, not whether they're going to be proved later or not, but just based on this story here, could these possible defenses apply? That wouldn't stun me. But I haven't looked deeply into it because my assumption was a long time ago when they started changing these statute of limitations that it was going to be the case that her suit would come back. And it appears that is definitely the case since both sides agree. And when's it going to happen? Who knows? Walter still has a reply brief that she gets to file responding to Manson's arguments against her arguments. And then the Court of Appeals gets to it when they get to it. So if you want to read this stuff, go find it. And there's some interesting things in it. I'd be curious as to what you think the actual arguments are and how they stand up based on the documents themselves, because I've only quickly read through them. When the parties agree the case is going to come back, I just didn't feel the need to delve too deeply into it. Well, that's it for now. Thanks. Bye.